Good morning and welcome to the ParkBridge Wealth Management Fall Webinar Series. This program is entitled Moving to Israel, Top Financial Planning Considerations. Before I continue with my normal introduction, first an exciting public service announcement, which is that I'm thrilled to share a significant milestone in our journey as a company. Shenkman Wealth Management has now been renamed ParkBridge Wealth Management. Given the rapid growth of business, it made sense to rebrand as we enter this next phase of growth. While the name has changed, our commitment to high-quality content, client service, and providing sophisticated advice has not. This is just the beginning of an exciting new chapter. If you'd like to stay abreast of our latest writings, podcasts, webinars, educational videos, and more, be sure to sign up for our monthly newsletter at parkbridgewealth.com/newsletter. Now back to our regularly scheduled program. For those who don't know me, my name is Jonathan Shenkman. I'm the President and Chief Investment Officer of ParkBridge Wealth Management. In that role, I serve in a fiduciary capacity to help my clients achieve their financial objectives. The goal of all my programs is to bring professionals together to help them better serve their clients. This is done by educating attendees on the latest topics in wealth planning and by encouraging collaboration between a client's attorney, CPA, and financial advisor where appropriate. My practice focuses on working with high net worth families, businesses, and not-for-profits. I manage individual investment portfolios, trust accounts, corporate retirement plans, and endowments to help my clients achieve their financial goals. In addition to the 25 or so events I run every year, I also do a fair amount of writing on the topics of investing and financial planning. You can read my work in a variety of periodicals, including Barron's, CNBC, Forbes, Kiplinger, the Wall Street Journal, the CPA Journal, and Trust and Estates Magazine, to name just a few. You can see all my work on my website at parkbridgewealth.com/articles, or by following me on social media at Jonathan on Money. Additionally, you can check out my weekly podcast, which is also called Jonathan on Money, and you can listen to that on Apple, Spotify, or wherever you get your podcasts. Today, we're very privileged to hear from Boaz Feinberg, who is the partner and the head of the tax practice at Arnon, Tadmor, Levy, based in Tel Aviv, Israel. Before I share the rest of Boaz's bio, I just want to extend a very special thank you to him for taking the time to speak. I'm sure giving a webinar on financial and tax planning is the last thing on his mind in light of the horrific terrorist attacks perpetrated by Hamas on Israeli civilians and the ensuing war in Gaza. I want to express that our thoughts and prayers are with his family, the people of Israel, the hostages, and the soldiers on the front lines. Now, by way of background, Boaz has nearly 2 decades of experience in taxation and financial regulation on both administrative, regulative levels, as well as in litigation. In the area of domestic and international tax law, Boaz specializes in advising and acting on behalf of corporations and high net worth individuals. He also provides advice in tax planning on mergers and acquisitions and other complex international transactions. In the field of civil law, Boaz advises various trusts throughout their establishment and ongoing activities, advises and represents clients before the Israeli tax authorities and various judicial instances, including in the Israeli Voluntary Disclosure Program. Today, Boaz will be speaking on moving to Israel, top financial planning considerations. And with that introduction, I'll now turn the program over to Boaz.
Thank you very much, Jonathan, for the warm introduction and for having me as always. And good morning to everybody. Speaking here from Israel, as though you all know, we are going through dire times since Simchat Torah, October 7th. But I can tell you that aside to the atrocities and the misery and heartbreak on the families of people who were murdered and abducted, you can see the strength of Am Yisrael. You can see the people, everybody in Israel are engaged, volunteering, making sure that we're all going through this together. And we will prevail, and we are all optimistic that we will prevail. And with the bad things that are happening, we are optimistic. This is one chapter, a very miserable chapter, but only a chapter in Medinat Israel, the state of Israel, and the Zionist project. So we have half an hour or even a bit less to go through things that are related to moving into Israel, specifically based on tax issues. The agenda will consist of discussing shortly the 10-year tax holiday for Olim, a step up in basis conundrum, which is something that I haven't discussed in previous webinars that I gave, which is something interesting and very unique to certain circumstances. Real estate taxation, I will remind the people what happens if they make aliyah and they purchase either a residence or a commercial property, whether they do this from Israel before they enter Israel. A bit about taxation of trust, which is something that I could talk about for hours, just that topic. And we'll end with wills and DPAs on durable power of attorneys. The legal infrastructure in Israel when it comes to tax, basically two major laws that concern us. One is the income tax ordinance from 1961, and the other is the land tax law with purchase and sale from 1963. And just definitions for today's topic: Aliyah and Oleh, people who immigrate to Israel and become citizens of Israel. Anyone who is Jewish or has Jewish ancestry may come to Israel and become a citizen of Israel. You do need to note, though, that making Aliyah, becoming a citizen of Israel, doesn't necessarily make you an Israeli resident. And the verse also applies, meaning if you come to Israel, even if it's on a tourist visa, and I can assure you that if you're Jewish and you extend your tourist visa, nothing really bad would happen to you just for staying longer in Israel. But there are many of those who come to Israel, do not make the Aliyah process and think that by that they do not become a resident of Israel. And that, of course, is a mistake. You may become a resident of Israel for tax purposes if your center of life is in Israel, meaning all the indications that are connected to your center of life, your place of residence, the time you spend here, if you spend an ample amount of time in Israel, if your social life is here, your financial ties are here, then you become an Israeli resident. Even if you're not, despite the fact that you did not become actually a citizen and do not make the Aliyah process. With regard to the 10-year tax holiday, the 10-year tax holiday for new immigrants and for senior returning residents, those who spent more than 10 years, consecutive 10 years as foreign residents of Israel, they still enjoy since 2007 the 10-year tax holiday, which provides for certain tax benefits. The first and foremost, 10-year tax holiday on foreign sourced income, whether those are passive or business in nature, and as long as the income is derived outside Israel. With regard to passive, pretty straightforward. If it's dividends from companies, if it's interest payments on loans, and if we're discussing business income, then there's the issue of where are you actually providing the services from? If you have a business, and let's say, for example, that you're a doctor and you decided to make Aliyah to Israel, and you provide services from Israel via Zoom or on email and on calls, that would mean that you're actually providing that service from Israel, and that would mean that you are generating business income from Israel. The tax authorities say that the way to determine what portion of the business income would be taxed in Israel and what not is based on the number of days that you spend during a tax year. Tax year, by the way, in Israel is from January 1st to December 31st, similar to the United States. And if so, for example, you spend 4 months outside Israel in the United States, meaning patients, clients, whatnot, and the rest of the time you are in Israel spending time here, then the tax authorities would make the same allocation and would claim that the 8 months that you spend in Israel would be taxable in Israel on the proportionality of your income. That, of course, is something that may be disputed by the tax person, and he may claim that even though he spent, let's say, for example, those 4 months, but he would claim that the value to the work that he is providing is much more significant from the work that he's providing from outside Israel, then he may claim, based on an economic valuation that he may get, that it is actually more than 4 months that should be allocated to the non-taxable income that he is generating. The other thing that you get under the 10-year tax holiday is an exemption on reporting on your foreign sourced income. This is something that the tax authorities for a very long time have been against and wanted to ratify. As today, they did not manage to do so. We're pretty sure that they are looking to do that, and we're now dealing with other issues that are much more burning than dealing with the exemption on reporting. But we're guessing that this exemption specifically will not stay for a long time. The other thing is the 10-year linear defense on capital gain. You get, if you make aliyah, and as long as we're discussing an asset that is outside Israel, you get the 10-year tax exemption on the capital gain on the sale of such an asset. And moreover, you get a linear defense on the time that is the spread between the date of the purchase of the asset and the end of your 10 years. So for example, if you purchased a share in the year 2000 for $1, you made aliyah in the year 2010, and you ended your 10-year tax holiday in 2020 and sold the asset in 2030, that will mean that, and in 2030, the share is worth $100, then you have a $99 spread in which the proportionality of the time elapsed between 2000 when you purchased the asset and the end of your 10 years tax holiday in 2020 out of the time that elapsed from date of purchase to the sale, that portion would be tax exempt in Israel. So it's not about a step up in basis. You do not get a step up in basis when you make aliyah. All right, the asset will be its value and the spread will be determined as any other asset from the date of purchase, original purchase price and date. But you do get the linear defense, and that is as long as you are the person who is selling the asset. And we'll discuss the issue of the step up in basis conundrum in a minute. One more thing that should be noteworthy: special circumstances for students and soldiers. Soldiers, specifically those who are coming now, and there are many of those who are coming, and we're very grateful for those who are coming to volunteer in the Israeli army right now, and those not necessarily in the army come in and volunteer in all sorts of other projects to assist with the survivors of the massacre and many others, and we're of course grateful for those. But if you are a soldier, and as long as you did not make the act of aliyah and did not become a citizen of Israel, the time you spend here in Israel as a soldier, even though you would be considered an Israeli resident because your center of life is here, that time would not be considered as if you are an Israeli resident. You will be considered a foreign resident for that purpose. And a special effort for students who come here for studying in Israel, and they have at least 50%, half a curriculum. They are entitled for the first 3 years of their life in Israel, even though they are living here and their center of life is here, not to be considered Israeli residents. So a person who comes, for example, now and is studying in college or in a kollel, in a yeshiva, or in university, of course, then for the first 3 years, as long as he does not make the aliyah process and does not become an Israeli citizen, then those 3 years he would be considered a foreign resident and will not owe taxes in Israel on his foreign sourced income. And then if he decides to stay in Israel, then he would start his 10-year tax holiday from that point on. The issue of the step up in basis conundrum is something that is specifically unique to a circumstance which is not uncommon, of a person who makes aliyah to Israel after his children are already in Israel. And that is, of course, something that may happen. A person who has his children come to Israel, live in Israel, raise a family, his grandchildren are here, And now he has a debate on whether he would retire in Florida, for example, or Arizona, or perhaps come live in Israel. And Israel is a great place to retire. And you also have the benefit of being close to your grandchildren and your children. And so that's all good and well, except that once you enter into Israel, your assets are entering the Israeli tax net. Now, we discussed in the previous slide that if you enter Israel, you get the 10-year tax holiday on capital gain, and you also get the linear defense. But if you pass away, and now the asset is inherited to your child in Israel, when he sells the asset, he did not get a step-up in basis. He's not entitled to a 10-year tax holiday. Let's suppose that he's already way over those 10 years. That would mean that when he sells the asset, he would have to pay taxes in Israel on the entire spread from the original purchase date and on the original purchase price. And that is the reason for that is that Israel does not have estate tax or inheritance tax, and therefore there is no step-up in basis upon inheritance. There is a possibility if the person who passed away did not move to Israel and his child in Israel receives the asset, then there is a unique ruling that you may file to the tax authorities requesting to get a step-up in basis for the date of death. But that would not be applicable if the person who passed away moved to Israel before that. There are things to do about that, and if anyone wants to further discuss this specific issue, then I'm happy to discuss this in private. You can reach out to me in an email, and we can further discuss. There are things that you could do that would minimize and mitigate the tax exposures, which may be immense. I can give you another example. Since there is no step-up in basis, that would mean that if the original purchase date and price were not by the person who passed away, but rather by his parents, and those parents passed away after 1981, then the original purchase price and purchase date can go all the way back to the grandparents purchasing the asset. So it could really get to an enormous tax bill if you do not take care of that specific issue of the step-up in basis. Moving along, real estate taxation benefits for new immigrants. Just a primer on this, Section 9A, we are discussing just the purchase tax, not the capital gain. The purchase tax in real estate transaction, purchaser is required to pay real estate purchase tax, which would be at a rate relative to the value of the sale or at a fixed amount determined by the type of sale of the real estate. And there is a distinction between vacant land or commercial and living apartment or residential apartment. If it's a land, then whether you are a foreign or an Israeli resident, you would pay 6%. If it is a residential, then you would find yourself, if you're a foreign person, paying a minimum of 8% and up to 10%. And you can see the steps. The 8% is up to 5,800,000 shekels, and anything above that you would have to pay 10%. If, however, you're an Israeli resident and you're purchasing your first apartment, then you have two separate types of easements on the purchase tax. One is if it's a single apartment, then you would pay substantially lower purchase tax. The first 1.9 million shekels would be not taxed at all. Anything between 1.9 to 2.276 million shekels at 3.5, and as you can see in the slide. However, in addition to the single apartment, there is also an easement for a new immigrant, someone who actually made the Aliyah process, became a citizen of Israel and has a Teudat Oleh. He can purchase his apartment as long as it's his dwelling apartment and would pay on the first 1.9 million shekels 0.5%, and anything above that a max rate of 5%. It will not go up to the 8 and 10%. So as an example, I used a simulator on purchase tax. If you purchased an apartment in Israel for $3 million, for example, if it's your single apartment easement, then you would pay 646,000 shekels. And if you're using your Oleh Chadash exemption, then you pay only 490,000 shekels. So that's an example for an apartment worth $3 million. One other thing that is not written here, if you purchase your apartment before you make the actual aliyah, before you become an Israeli resident, you still may enjoy the single apartment exemption and the new immigrant exemption, provided that when it comes to single apartment, you purchased it 2 years before your aliyah, before you became an Israeli resident. And for new immigrants, you have 1 year before you became an Israeli resident to purchase the apartment and then move to Israel. As to trusts, trust is something that is very common in the United States, not necessarily for asset protection or for tax planning, but rather as a substitution to probate. Many Americans who are using a grantor trust, where they are usually both the sellers, trustees, and the beneficiaries. And Israel treats the taxation of trust was something that is fairly new since 2006 and revised substantially in 2014. And the taxation of trust, particularly for international families, is a nightmare in Israel. I have to tell you, it's not an easy issue, and you must be well prepared before you touch base in Israel, whether it is you as a settler, whether it is any of your beneficiaries. You want to make sure that you are not getting hit by unnecessary Israeli taxes. The way that trusts in Israel are taxed is based on their classification. The classification are based on the identity and residency of the settler and the beneficiaries. It is not based on the registration of the trust, and is not based on the identity of the trustee. So it all depends on whether the settler or the beneficiaries are Israeli residents or not. And if one of them is an Israeli resident, then you're starting to get into taxation of trusts in Israel. The Israeli resident trust, the regular trust, I would say for tax purposes, is usually when the settler is an Israeli resident. And it doesn't matter for that matter if the beneficiaries are in Israel or not. Once the settler of a trust is an Israeli resident, then it's an Israeli resident trust. That would mean that if you are in the United States and you make aliyah, and that would automatically, if you have a trust, would turn that trust into an Israeli resident trust. Another way to have an Israeli resident trust is if a person who is the beneficiary of the trust makes aliyah, becomes an Israeli resident, and the settlers, none of them are alive. And those, of course, could be also common trusts, especially if they are generation skipping trust, in which the grandparents formed the trust, were the settlers of the trust, and when that beneficiary comes into Israel, they are no longer alive. That also would be classified as an Israeli resident trust, which basically taxes the regular income of the trust in Israel in its full. And this is another issue that we're having trouble with, the way that the law was drafted and the interpretation of the Israeli tax authorities. In their mind, under their interpretation of the law, it doesn't matter if there are other beneficiaries of that trust who are not Israeli residents. Once you have one beneficiary living in Israel, and the settlers are not alive, and there are other beneficiaries who are living outside Israel, that will be classified as an Israeli resident trust if the settlers are not alive. And that means that the entire trust income would be taxable in Israel in the eyes of Israeli tax authorities. A lot of things that you need to make sure you do before you make aliyah in order to mitigate that exposure. The relatives trust, also common when it comes to immigration to Israel, is when a beneficiary moves to Israel and the settlers are still alive. That type of trust is taxed in a different way than an Israeli resident trust. It would be usually on a default position be taxed on the actual distributions made to the Israeli beneficiary, or if he wants, he may elect to tax the regular ongoing annual income of the trust that is allocated to his share. And that is also something that needs, of course, knowledge and planning before making the aliyah. And then there's the foreign beneficiary trust, which is also something that may be used by those who come live in Israel and know specifically that their beneficiaries would probably never come live in Israel. And then you can use the foreign beneficiary trust, which is a trust that basically would keep the assets, the income, outside the Israeli tax net as long as those beneficiaries do not become Israeli residents. So that's another thing that is usually used by settlers who have a trust and wish to plan ahead. With regard to will, a will, unlike in the United States, a will is something that is commonly used in Israel and not grantor trust as a way to distribute the assets of someone who passed away to his inheritors. Wills in Israel are usually have no limitations on the testator's wishes under a will. He can decide to bequeath to any person he wants. It doesn't have to necessarily be to his family. He can decide on allocation. He can decide almost whatever he wants under an Israeli will with no limitations. If a person, by the way, comes to live in Israel and passes away and has no will, then the intestate inheritance would provide for the 50-50 rule. 50% goes to his spouse and the other 50% to his immediate descendants. And there is the concept of the mutual will, which is something that is commonly used in Israel to make sure that if you have a couple and one of them passes away, you want to make sure that the remaining spouse would not bequeath the inheritance to others other than the children of the person who passed away. So the mutual will is a mechanism that would allow for that portion that was inherited to the remaining spouse, the surviving spouse, to be bequeathed to the children of the surviving spouse after his passing. And lastly, with regard to durable powers of attorney, it's a fairly new legal tool since 2017, allows the person to determine who will take care of his matters and make decisions on his behalf. If he is in capacity and financial health issues, it must be prepared by a lawyer who is certified to perform a durable power of attorney. And there are certain issues that you need to know. What are things that are allowed to be under a durable power of attorney, and what types of assets and gifts that you want to make on behalf of the person require a court's ruling. For example, real estate is something that cannot be determined under a durable power of attorney. If the person holding the power of attorney wishes to have any transaction in real estate, he would have to approach the courts. That's just one example. I think that's it. And I was able to put all that in less than half an hour. And I wish to thank everybody who participated in this. And of course, any questions you may have, I'm happy to answer in email. And I'm sending this back to Jonathan, and I wish to thank you, Jonathan, again for this opportunity.
Great. Thank you so much, Boaz. If anyone has any specific questions, new business opportunities, or any other issues they'd like to discuss, please feel free to reach out directly to Boaz or myself where appropriate. I'll be sure to include his contact information in the follow-up email to this program. As I mentioned at the onset, the goal of these programs is to stay up to date on timely wealth management related topics and to collaborate where appropriate. And I think we can all agree that the clients who are best prepared are the ones that are served by a team of knowledgeable advisors. 4 more quick items before I let you go. First, my fall webinar series continues on November 30th on the topic of last-minute 2023 wealth planning ideas, ensuring your clients make the right moves before year-end, featuring yours truly, Jonathan I. Shenkman. It is sure to be a riveting program packed with practical information, and I'll send out an invitation to this event in the coming days. In the meantime, if you have a friend, colleague, or client who would like to be notified of my upcoming webinar series, they can email me with the word webinar in the subject line, and I'll add them to my webinar distribution list. My email is jonathan@parkbridgewealth.com. Second, you can follow all my work on Twitter, YouTube, and Instagram at Jonathan on Money. And you can also listen to my podcast, also called Jonathan on Money, which is available on Apple, Spotify, or wherever you get your podcast. Third, please take 30 seconds to fill out my survey at the end of this program. It helps me improve my webinars and provide timely and interesting content to attendees. I thank you in advance for that. And finally, I want to once again express our thoughts and prayers and best wishes with Israel. And I'm praying that the 240 hostages will be returned home in the near future, that Hamas will be eliminated. And I'm also hoping for an ultimate and lasting peace in the region. And with those thoughts, this concludes today's session. Please stay safe and healthy and have a wonderful day, everybody.